All right, welcome to a Colorado real estate exam prep. Super excited for today. And what we're going to go over requirements governing the activities of a licensee. And so this is 11 questions. 11 out of your 74 questions are just this section right here. So this is 15% of your exam. And we can kind of see like kind of what it jumps around and is looking through, right? We're talking about advertising, broker administration, because you're in Colorado and you're going to be an associate broker. And so you need to know about some admin pieces because in all reality, you hold the highest licensure in the United States in the state of Colorado. We're going to talk about conflict of interest with license status, practice of law, and the illegal practice of law, sign crossing, personal assistance. We're going to look at some stuff today, right? And what we're going to do, again, out of 74 of the questions that are on the state side of your exam, 11 of them are just going to be in this section. This is all we're going to live in today. And this is going to look like more of um, really just a cram session, right? I know this is how we kind of push this, and this is kind of what it looks like. And what we're going to do is we're going to go through there. This is going to be like a mini lesson, and we're just going to dive into it. We're going to dive into it in order. So let's look at this thing. So start off with advertising and trade names. All right. So what's neat about this is that you are getting into a profession where you get to build a brand around you, right? You are the brand. And yes, in the state of Colorado, you know that you have to have 2 years of supervision. That might be an exam question. And with that 2 years of supervision, you still get to build a brand inside of a brokerage. So there's some rules with that. And it's clearly indicate that your license status, right? So first and foremost, that's a pretty big deal, right? Because if you have an inactive license, if you have an expired license, you're no longer able to practice real estate. And so that might seem like a dumb moment right now. And yet you're going to get tested on it because it's way more common than you would think that you let your license lapse for one reason or another. And then someone raises their hand and they say, hey, I'm interested in buying or selling real estate. And you don't have an active license. And so before you can get into that conversation with them, you might have to do some CE credits or you might have to do something to reactivate your license so that you can be in compliance with the state of Colorado. Use only the brokerage's registered trade name. Okay, so when we're talking about like what has to be on your sign, what happens to be on your business card, your website, your social media, it doesn't matter. You don't have to have your name. You don't have to have your phone number. You should, right? You absolutely should. You are your brand. And the only thing that needs to really be there is the brokerage's name. However, the brokerage is registered. That is the only thing that needs to be on the signage on the website. And really, what that's for is if you get in trouble, right? Like they want to know where to send the fine. In the grand scheme of things, that's all that really is, right? Like they want to know where to send this. So the brokerage's name. And then ensure all advertising complies with the commission. It's your responsibility, right? Like the commission isn't really policing this. Okay. The commission isn't policing if you are licensed or unlicensed, and they're not policing if your signs are in compliance. You know who is? Your client that you frustrated, your competitor that feels like they should have got the deal that you didn't, the neighbor that someone parked in front of their house and they didn't like that someone parked in front of the house, so they turn you in. Like that's how this thing happens. So it's your responsibility to make sure that you're following the rules, because what's going to happen inevitably is someone's going to get frustrated with something, they're going to turn you in. And so what we have to do is make sure that you are 100% in compliance at all times. Now let's jump into brokerage administration. And we're talking about employer versus employee relationships. And I think one of the biggest things to keep in mind is when you're talking about an employee versus the employer versus a 1099, right? And what we do is we talk about employee versus employer, even though you know that you're a 1099 in the state of Colorado, like you're going to have an independent contractor agreement, and they can't dictate the hours that you come in. They can't say that you have to be here or you have to be there. Like that's not what this is. But yet we look at it as employer employee. All right. And so one of the biggest things that we have to know is that you're a designated broker. in the state of Colorado, right? And all that means is that the managing broker has deemed you the point person, the agent for the consumer. Yet it's the brokerage's client. All right. So on paper, it's the brokerage's client. I know you are the brand. You are the person that this could be your best friend from high school. This could be your significant other. This could be you buying a house, selling a house. Yet the way that the law is written in Colorado, that it's the brokerage's client. So all monies, all compensation have to go through the brokerage. Now, the only time this is different is, let's say you leave a brokerage, right? Let's say you were doing a deal, right? You're doing a deal, you're about to close on 123 Main Street, and yet you're going to change brokerages. You go to a different brokerage, you go from brokerage A over to brokerage B. It's perfectly legal for brokerage A to pay you directly. All right. They don't have to pay. Brokerage A doesn't send the money from them to brokerage B to you. They'll pay you from brokerage A, even though you're now at brokerage B. So again, all monies have to go through your brokerage. The only exception is if you leave a brokerage, that brokerage can pay you directly. And then compensation disputes are handled through civil courts, and the commission has no authority in these matters. So let's say that something pops up, right? That your client doesn't pay you, or even another brokerage, right? Let's say that you're a co-op, right? And co-op, I want you to always know that the co-op means that you're the buyer's agent. Always. It never means you're the listing agent. You are always the buyer's agent as a co-op. And so you're the cooperating broker, and the brokerage doesn't pay you. The commission's not getting involved in this. All right. So you would actually have to take somebody to court, whether it's your client or another real estate agent. The only time this would ever really be different is if it was realtor to realtor. And keep in mind that not all real estate agents are realtors, right? And so all realtors are real estate agents, but it doesn't go the other way. And so that's a trade association, and there's ethics involved, and there's a lot of other things. So if there was a dispute, realtor to realtor, then the association would get involved. It would actually go to CAR, the Colorado Association of Realtors, and that would happen. Yet the Colorado Real Estate Commission does not get involved with commission disputes. Place of business requirements. Your employing broker has to maintain a physical business address, not you. All right. Let's say that what's neat about this thing is you could, in theory, get licensed in every state. You could get licensed in all 50 states if you wanted to. That sounds painful, but yet you could do it. And you might not live in the other 49 states. You, as the real estate agent, you don't need to have a physical place of business. Your brokerage does. The employing broker has to have a physical place of business. And when we're going through, they have to have all the records that are available on site. Now, here's the thing: they don't necessarily need to have a cabinet, right? They're a filing cabinet. There's not some giant filing cabinet that's in a lot of these brokerages. Now, I have been to some brokerages where they do have like the old school library, right? Where it's like the moving bookshelf where they do the rolling thing and it moves across, but yet that's an older brokerage. And with that being said, they can be digital. But the commission, if they're going to audit, what they're going to do is they want the ability to actually show up to a physical address, and for them to be able to say, hey, show me these specific transaction files, and for someone to be able to pull them up on site. And again, they can be digital. They can be in a locked filing cabinet. Now, if they are in a locked filing cabinet, they have to have confidentiality requirements that are attached to it, right? And so what that means is, what we know in the state of Colorado is you're the designated broker. You're the designated broker, and your relationship does not extend to anybody else in your brokerage, just you. All right. It doesn't extend to your managing broker. It doesn't extend to the person that's supervising you. It doesn't extend to the people that you have a team meeting with. It doesn't extend to anybody. So there has to be rules in place to make sure that your client's data is protected from every other person in your brokerage. Because keep in mind, right? Like we're sharing printers. And so you could print something to a printer, and then there has to be rules around how we're going to handle confidential information. So that's why there has to be requirements around how we're keeping things confidential. And that actually shows up in the office policy. All right. So when we're talking about the office policy, your brokerage, your managing broker has to have an office policy, not you. All right. Not you, the broker, the real estate broker. Your managing broker has to have a written office policy. All right. And so that written office policy is only for multiple person firms. All right. If you're not a part of a multiple person firm, all of you on this call, right, are going to be in a multiple person firm, at least for 2 years. Most agents in the state of Colorado, they stay in a multiple person firm because it's way less of a headache. And with that being said, as an independent broker, a single person firm, they don't need to have an office policy. All right. The playground rules are the same for everybody because it's just one person. Office policies are really just the playground rules. It says how everyone inside of those four walls is going to operate. All right. So when we're looking at this thing, we have what does the transaction process look like? All right. We're going through, it says brokerage relationships. It's talking about confidentiality. It's talking about fair housing. It's talking about unlicensed assistance, right? Like it's going through and is talking about all of the things that could and do show up, right? Especially brokerage relationships. And I think brokerage relationships is probably one of the bigger ones, right? That you're going to see multiple tests around. And when we're talking about brokerage relationships, right, is that you have to have a written office policy, your brokerage does, on what kind of relationships that you are allowed to offer to the public. You could go to a brokerage that says you can't help someone as an agent. You have to help people as a transaction broker. Or they could say, we actually don't help people as a transaction broker. We're only allowed to do agency. All right. And so while your license is good for all of them, your license, you can be a transaction broker in the state of Colorado. You can be a real estate agent. You can help someone as a customer. Your brokerage might not allow you to. And that would be covered in the office policy. So then when we got commissions, rebates, referrals, and fees. So you guys are allowed to pay a commission to people that are licensed, only that are licensed. All right. So brokers are the only ones that are allowed to get a commission, right? When we're talking about anything else like an auctioneer, someone that's doing something like that, that person does not qualify to get a commission. All right. They can get paid a flat fee. It can't be a success fee, but yet they could get paid for actually doing some kind of service, but they can't get a percentage of the proceeds. Rebates and inducements. I think this one gets a little bit tricky. All right. And so when you're working with a seller or a buyer, it is perfectly legal to rebate part of your commission back to them. All right. So if you're working with a buyer, for example, this is kind of where I would see this show up. And we're going to call it an inducement. And so what this looks like is that you're talking to this buyer and you say, hey, Mr. Mrs. Buyer, if you work with me, what I will do is when we close on a house, I will rebate part of my compensation back to you, and we'll be able to use that for discount points, right? To pay down part of your closing cost, right? Like that's perfectly legal. You could absolutely do that. Yes, it has to be on the settlement sheet, right? Everything has to be going through the right paperwork. You can't just cut a check, right? Cutting the check outside of closing would be loan fraud. That would be illegal. And what you can do is you can actually cut this check through the process and it can be paid to their lender and it can help them with closing costs. Perfectly legal. And referral fees, right? So you can pay a referral back to anybody with a real estate license. All right. So this is what's neat about this business is mailbox money. All right. So it doesn't matter. You can have friends in any state, or you don't have those friends yet, but you're going to make those friends. And you can refer business back and forth. And you get a phone call, right? The phone rings and you answer and they say, "Hey, I got a buddy that's moving to your state. And I was wondering if I send them to you, would you give me a 25% referral?" And you're going to be like, "Absolutely. I didn't know this person yesterday. And you're telling me that they're looking to transact business. I will absolutely cut you back 25% once this thing closes." So they have to have a license. All the rules are pretty much the same. Like, unless they're in a country, and there are countries out there that don't require real estate licenses to actually practice real estate, but every state in the United States does, and most countries do. So they have to have a license and they have to follow all the same rules as that we would follow in Colorado. And you can actually send out that referral. Then we have this thing called disclosure of conflict of interest or of license status. Again, you have to make sure that if something happens with your license, your consumer has to be informed. So let's just talk about your managing broker. Let's say your managing broker's license gets suspended. Well, what does that mean? That means every license underneath that managing broker, their license gets suspended as well. So you now have a suspended license. You are in the middle of a transaction. You don't have an active license anymore. You actually have to halt all activities. And you have to inform your consumer, right? "Hey, Mr. and Mrs. Seller, my license is inactive." Now, here's the thing. Like, you're going to figure out how to fix that really, really quickly. Like, we're going to either figure out that does somebody need to elevate a new managing broker into that spot, or did that managing broker lose their license? And then at that point, you might be jumping ship to a different brokerage pretty quickly, right? We know that you can change brokerages. You just have to pay the fees. Perfectly legal. In the state of Colorado right now, it's like $25. It's $25 to leave a brokerage and go to another brokerage. So anything happens with your license status. And again, if it happens to your managing broker's license, it happens to yours as well, right? So if their license goes inactive, it gets suspended, it gets revoked. Your license doesn't go and gets invoked, but it goes inactive because you have your license under somebody. You are part of a multiple person firm. You have a employing broker. Anything that the employing broker's license disappears, anything happens with them, your license goes inactive. All right. And so that's important to know. Theirs gets revoked. Yours doesn't get revoked. It goes inactive. Theirs gets suspended. Yours doesn't get suspended. It goes inactive. And we have to let your consumer know. And then conflict of interest, right? Like, we have to let the consumer know any conflict of interest. What was interesting, I was just on a standards continuing education yesterday, and the day before it was 8 hours, 8 hours of professional standards is what I was on the other day. And with that being said, there was a lot of conversation around this conflict of interest. And one of the things that they popped up was they had a seller and it was an off market deal, right? So the seller was like, "Hey, I don't want to put the home on the market." And the agent still went out and still had some conversations with some people. I don't know if that was in the client's best interest or not. I think they thought that it was in the client's best interest. But yet, that one of the people that they told was their sister. All right. So they told their sister, "Hey, I got this deal, this house. I actually think this house would be perfect for you." It turns out it was. So the agent brought their sister, showed them the house, and the seller was like, "Okay, yeah, absolutely. Let's put this deal together." They never disclosed that the buyer was a family member. Well, that is a conflict of interest, right? So if you're dealing with buying something for yourself or a family member or even a close friend, you have to disclose that, right? Because here's the thing. If I meet someone off the street and they want me to either help them buy or sell, and I have a family member, a friend, myself, who do I want to win? Well, obviously, family member, myself, my friend. That's the person I'm going to put above everybody else. You just have to make sure while it's perfectly legal to do that transaction, you have to make sure that the other party is aware of it because that would be a conflict of interest. All right. So anytime that there is a family member, yourself, or a friend, or if you have a financial interest in something, right? So let's talk about property management. So we're doing property management. I don't recommend anyone on this call do property management. And you're doing property management and something breaks because that's property management. Something's going to break and something breaks, and you have a plumbing company that you own or a family member owns. And it's perfectly legal for you to give them that job. But the owners of the house or whoever's paying for it have to know that you have a financial interest. All right. That'd be a conflict of interest if you had a company that you actually said, this is the best company, and they might be, but it's going to look a little weird if you were making money from the company that you referred and no one knew that you owned it or had some kind of financial incentive to put that company above everybody else. So we must disclose. Disclosure is huge. Anytime, right? Like anytime that you think that disclosure might become an issue, you probably should disclose. So let's talk about handling documents, right? So the big one in here is you have to keep all copies for 4 years, right? So any contracts, disclosure, settlement statements, like we're looking at this thing. What this tells me is really it's just that second bullet point that you see. If it was signed, I have to keep a copy of it. Now, when we're talking about like brokerage disclosure and we understand that consumers don't have to sign that because it is really just a disclosure, it's not a contract, and it actually states it in there that they don't have to sign it, we're going to have to keep that too. So, really, anything, and where my head goes is if someone signs it, I obviously have to keep it. The exception to that would be that brokerage disclosure. Even if they don't sign it, I still have to keep it. Now, here's the thing, it's you keep it for 4 years after it completed or 4 years after it failed. All right. So let's just say that you help someone buy 123 Main Street. That starts your 4 year time period, not from when you got the paperwork signed. It's 4 years from completion. Or let's say that you in that relationship, right? So you and the seller, you guys break up. You decide that you weren't a good fit for each other. The way that you want to market is not the way that they want you to market. And you're like, you know what? It's probably better if we just kind of walk away. Well, you sign the termination paperwork. It's 4 years from that termination paperwork that you have to sign. You have to keep all that stuff. So it's the 4 years after it either completes or terminates. And then again, anytime somebody signs, right? Somebody signs a document, they must get a copy. All right. They must get a copy. What I don't have in here is the settlement statement. And I think it'll show up in a different section, not necessarily in here. But with the settlement statement, you're going to have to make sure that your managing broker gets a copy of it immediately. That's actually the answer is immediately. So if you do get a question around just like the handling of a settlement statement, the settlement statement must be given to your managing broker immediately. And if you're wondering what immediately is, I don't know the answer, right? That's one of those things where it's going to pass a smirk test if you get audited and they want to know why it took you 3 days or 4 days or even a week before it was actually put into the system for holding records at your brokerage. But it's going to be immediately. All right, let's talk about listings. All contracts, right? When you're talking about a listing contract, we're talking about the exclusive right. We're talking about the exclusive right to buy or the exclusive right to sell. They have to have a definite termination date. All right. That termination date can be up to 1 year. It could be one day, 1 month, 6 months, 8 months, 12 months, right? 365 days. There's a definite, this is when I'm starting to do business with you. This is when our relationship ends. 365 days is the max. Also, with that being said, like one brokerage can assign a listing contract to another brokerage. And you're probably asking yourself, why in the world would that happen? Well, keep in mind, you're with brokerage A and you're working with a client. You go over to brokerage B. Here's the thing, the brokerage, yes, owns the listing, but guess what? Your client's doing business with you. They don't care about brokerage A. So, what brokerage A will most likely do is they are going to assign the listing agreement over to brokerage B, and then you are going to be the designated broker over at brokerage B. So it just needs to be assigned, right? And so the original contract is now, terminated, right? As we're going through here, and we have a new one that is going to be rolling if that agreement isn't signed, right? Because if that assignment doesn't happen, that's the real world of what really will happen if it doesn't. Is that person is probably going to terminate. They're probably going to fire brokerage A. Again, we're not lawyers. We can't tell somebody how to do that. That would be the illegal practice of law. Yet, if you go to a different brokerage, you go from brokerage A over to brokerage B. And again, that agreement's with brokerage A, and they don't release that consumer from the agreement, the consumer is most likely going to just fire them for something in the contract, and they're going to terminate that deal, and they're going to move over to the next, to back over to brokerage B with you. So single party listings. A single party listing is around a FSBO. All right. So a single party listing is a for sale by owner. And what this means is you're representing the buyer. So you're representing the buyer and you're treating the seller, the FSBO, as a customer. All right. That's how this is going to show up. So if you see anything around a single party listing, you represent the buyer. You are treating the FSBO, the for sale by owner, the seller, as a customer. What this also means is this. You have to let them know that there could be something around commissions, right? And all kinds of other stuff. And you also, if that deal falls apart, right? The buyer and the seller, don't end up buying and selling together, you no longer have anything to do with the listing. All right. So I think it's interesting when you read it. It's probably a little bit harder to understand, but when you hear it, you're like, that totally makes sense. I never represented the seller to begin with. So a single party listing means that I represented the buyer. They loved a for sale by owner that they found it on probably Zillow. And we wrote an offer. The seller accepted the offer. The deal fell apart. Maybe it fell apart during termination, right? Contingencies, those contingencies that we have, termination, around inspection, or around appraisal, or around conditional sale deadline, anything. It terminates. You are no longer associated with the listing. You're still going to work with your buyer, yet the listing is completely let go at that point because you were never the listing agent. And here's the cool thing. This is the whole reason why I became a real estate agent. You can buy and sell houses. And with that being said, you can actually collect a commission, which is pretty cool, right? So if you want to go buy a house for yourself, you get a commission. At least you get to negotiate it. They're not blanket offers of compensation, but yet you can negotiate a commission. If you sell a house, you don't pay a listing commission as long as you sell it yourself. All right. So here's one of the things, and this is actually where we talk about like the inducement, right? And so when we're talking about a licensee buyout addendum, is kind of where I would think this would show up, is more so here. Yet there's a lot of other things that could happen. So broker purchasing a listed property. You have a property listed and you decide that you want to buy the home. Well, here's the thing. First and foremost, now you were the designated broker for the seller. you can't be an agent for the seller anymore. You absolutely cannot be a transaction broker for yourself. So what's going to happen is now that seller is a customer. They're going to have to sign some paperwork, and it really is only going to be transaction specific. All right. So it's only for this transaction. If you guys end up don't doing the deal together, you can still sell the house and you would still represent them as a agent. Yet, if you're buying the home, you have to do a change of status, right? You have to do a change of status because you're now representing yourself as an agent because you obviously want yourself to win. So you can't treat yourself as a customer. You can't treat yourself as a transaction broker because in what world does that make sense? And so you also can't treat your current client as a client anymore in an agency capacity. You can't treat yourself as a client and the other party as a transaction broker because that's not how this works. So they're now a customer, you're your own agent, and now we do a change of status. The seller does not have to consummate the deal. All right. So the seller could literally, and I have seen this happen because I have agents that do this all the time. And the seller could actually say, you know what? I actually don't want to sell the house to you. You could go through all the steps. You could have had an inspection. You could have had the appraisal. You could have had everything. In the day of closing, the seller could actually pull away from the deal. Perfectly legal. I've seen that happen. So we just need to know that we're going to do a change of status. This is probably like an inducement. I would typically see this most of the times showing up in a licensee buyout addendum. And in the licensee buyout addendum, while this isn't a part of this section, the licensee buyout addendum, you're still marketing the house, which is what's interesting about this. Like you're still looking for a seller, right? And like you've agreed to buy it, but yet you're still looking for a buyer for the home. You have your seller, you've already told them like, hey, I'm willing to buy this house from you in, 45 days or whatever if I don't sell it. And I'm probably going to buy it at a discounted price. And that's what you're going to put in the contract. And during that whole time, you might do some due diligence, but yet you are still actively marketing the home. And the seller has the right to either go through with the deal with you or to say, you know what, I appreciate that you put that inducement in to have me list with you. And at the time, I thought it was a great deal, but let's keep it on the market for another month and let's see what happens. And that is the seller's right. Practice of law, seller financing. So, first and foremost, you do not have the legal capacity to interpret any documents that have not been commissioned approved forms. Rule F, Conway Bogue, right? Conway Bogue gave us the ability to practice limited law. And Rule F is the standard and approved forms that we are allowed to use. That's one piece of this. All right. So you can't go through, and we know that in our contracts it reads seek legal counsel, talk to a financial advisor. Like it reads that all over our contracts in the state of Colorado. We're not allowed to go through. And one of the pieces of this practice of law might be this: you're talking to some consumers, some buyers, and they ask you, should they take it as joint tenancy or tenancy in common? I actually think that's going to be a test question. Joint tenancy or tenancy in common. You're not allowed to advise them on which one they can take. You're allowed to tell them the differences. You're allowed to explain it to them, but you are not allowed to tell them how they should take title because that would be the practice of law, the unauthorized practice of law. Now, part of this section is going to be talking about seller financing. All right. Especially right now, interest rates are 7%. We live in Colorado. Our price point is high. Like we are one of the most expensive states in the United States to live. With interest rates, with the cost of money being where it is with our price point, we see people doing creative financing, right? This is kind of where the seller financing pops up, is where the seller's the bank. And there could be all kinds of different mechanisms they're doing to actually make some deals happen. And when we start talking about installment land contracts, lease purchase agreements, right? These like rent to owns, lease options, that is above our pay grade. All right. That's law at that point. We do not have the ability to advise. We do not have the ability to put this contract together. This is above our competency. If you were to get involved in this transaction, that is the unauthorized practice of law. And you're probably gonna get in trouble. Like you're definitely gonna get in trouble. I actually think you could potentially lose your license. There's also mechanisms in here where you could actually, if you engage in some of these things that might actually look a little bit more legal, you could actually lose your ability to do a FHA or a VA loan. Like you might be able to keep your license because it's not technically unauthorized practice of law, but if VA or FHA, like if HUD finds out that you've actually done this, they might not allow you to do an FHA or a VA loan. And that's like 30 to 40% of all loans that are done in the United States. And more so than that, they could actually take it away from the whole brokerage. So the whole brokerage could actually lose the ability to do those types of deals. And then when we're just going through again, guys, we know that we must tell people this has legal and tax consequences. You should consult with a lawyer or a tax professional. They don't have to. Most of the time, they don't, but it is our obligation to make sure that they know that's an option. So we have personal assistants, right? And so this is where it gets pretty neat. And they can be licensed or unlicensed, right? So if it's a licensed personal assistant, that's just a real estate agent. All right. So we know a real estate agent can do all the real estate agent stuff. Now, we probably have to put them in the contract somewhere if they're going to be doing different things for us that would constitute some kind of agency agreement. But when we're talking about unlicensed, because that's what you're going to get tested on, unlicensed assistants can pretty much do really anything, right? They can go through and they can do clerical work. They could put together documents as long as you supervise them. It has to be at your discretion. Like you could literally tell, hey, personal assistant, I want you to put these documents together. This could be listing property specific documents and they can put it together. You would have to supervise them. It has to be at your discretion. You have to tell them exactly what to do. You have to look it over before you send it. They can do it. They can go host an open house for you. They can go show property for you. Now, if they're doing something like that, you need seller permission because here's the thing in our contract, there's actually a checkbox that says who can enter into a seller's property. And the default ones that are there that are plainly written out is it does say unlicensed assistants, it does say licensed real estate agents, it says appraisers, it says inspectors, and then there's other like boxes that we can check. So we have to have seller permission to actually go through and put this information out there. And they can do research. They can do data collection. They can do all that for market analysis, right? We can actually go have them go scour the MLS, go pull information for us that we actually want to assimilate out, perfectly legal. What they can't do, they can't negotiate. They can't put contracts together. They cannot advise your client. Again, that would be the illegal practice of law. All right. They can't collect a commission for a real estate transaction completing, right? Like you can go through, you can pay them, but it can't be a success fee. Anytime there's a success fee, I don't care where it is, success fees, you have to have a license, a real estate license. All right. So you can pay them at the end, right? You can say, I'm not going to pay you your money until a deal actually closes, but you can't say, I am going to pay you because of a deal closing, right? That's where it gets weird. Yes, I'm not going to have the money until the deal closes and then I'll pay you. But you can't say I am going to pay you if a deal closes. That's where it gets a little bit nuancy. Also, the employing brokers will have this in the office policy. There actually has to be some kind of supervision for unlicensed personal assistants in the office policy. And sign crossing. All right. Guys, you cannot. Let's talk about agency agreement, right? So, agency means that you can go through and you can advise people. All right. So, when you become an agent, not a transaction broker can advise. but an agent can't. So an agent can go through and they can advise their client to material benefits and material risks, right? You can say, hey, I actually think that this home, historically speaking, this area has appreciated 4% year over year. And I actually think that they're doing a lot of, good things in the area. So I think that this might be a good rental. Perfectly legal. You can have that conversation. But that's as an agent. Now we're talking about someone that is under contract with another real estate agent. If you were to give them any kind of advice, help them put a contract together, anything like that, that would be the unauthorized practice of law. And you could lose your license for that. You are not allowed to approach anybody that has an active exclusive right. Okay. You can't, right? You're not allowed to do it. Now, here's the thing, they're allowed to reach out to you. So if someone reaches out to you and they say, hey, my real estate agent is the worst and I want to do business with you. Well, you can actually put together the contract and sign it for when their current contract ends. You are not allowed to advise them on how to get out of their contract. You're not even allowed to tell them if it's possible. What you can do is you can say, hey, I would talk to my lawyer if I were you, not your lawyer, their lawyer, because you're not going to give them your lawyer's information. And so you're going to go through, and that's what this is going to look like. So you cannot go knock on a door, go actually like literally cross a sign and say, hey, I see that this house has been on the market for 30 days. Your real estate agent is the worst. You want to do business with me? Illegal. If they call you and they say, my real estate agent is the worst and I want to do business with you, you can actually sit down, talk about everything that you're going to do, put the contract together to take place the day that their contract ends. Perfectly legal. And you're responsible. You are responsible for actually doing the due diligence to see if they actually have a signed listing agreement. All right. You're going to go through, you're going to ask the questions. And that's what it is, right? It's trust but verify. You're going to go through, you're going to ask them, and then you're going to find out, right, about their holdover, right? The holdover is a big deal. Like, let's say that they do have one or one just ended. You want to make sure that, hey, do you have a list of prospective clients or of prospective buyers or sellers that your real estate agent gave you, right? They have to give you that written document that says, hey, these are the people I tried to negotiate with that you said no to. And if you go under contract with them in X amount of days, you will owe me compensation, right? That's kind of where that procuring clause kind of will pop up.